to my learned colleague that we are going to object to this exhibit being read in record at this point in time for the following reasons, my lord. The court will recall that we asked specifically for this information because I was given instructions that on the 25th of October 2015, specifically, there were certain transactions showing and indicating that they were done in Nongoma by accused number 2. And when we look at the records furnished to us, those records are not reflected in this statement. Unfortunately, due to financial constraints, I cannot hire a forensic chartered accountant. However, I've endeavored with a friend of mine that's not in a personal capacity because she works for one of the institutions where a certain transaction is alleged to have happened. So she said she will ask her company whether she can access the backdated bank records of that specific date to see whether that swiped transaction appears on their bank records. So, my lord, I feel that until we have ventilated and corroborated or otherwise that information, reading this into record, my lord, will put me in a corner whereby, as in a 212 statement, if I accept it now, I accept it for its correctness and truthfulness, and later on I'll be squeezed in a corner to say, by the way, I have established that there was a transaction, so I need to come back to court and explain why now I need to explain that transaction at that stage. So it doesn't, my lord, I think, detract from the state's case to put this information later, once we've ventilated those transactions, my lord. As the court pleases, that's my submission.
Yeah.
Today, I want us to talk about Advocate Ramosepele and the one sentence that he said that piqued my curiosity. And, Advocate Ramosepele is always indebted to the court. And I say to myself, is this a free and fair trial? Is this a free and fair representation? Is it free and fair? Yes, legal aid is covering the costs of Ubongani Mzansi, but with that comes some financial constraints, because we saw, here's first example, we saw where legal aid, Umlungu, to the ballistic expert for the defense team, was seated in court for a couple of days until legal aid said, hello, or what is going on over there? The ballistic expert is only being paid for Advocate Mzansi Unfiltered and not for every one of the defense team. He is there strictly for accused number 3. And that's all the budget we have. Okay, that's where the budget ends. And then we saw where legal aid saw Advocate Ngomezulu do the trial within the trial from the beginning all the way to the end, representing the accused in the trial within the trial, that is Ramosepele and Ubongani Mzansi. And legal aid said, well, that's great, but who are you? And no, we are not paying you. We don't know what's going on here. And as you know, Advocate Ngomezulu was brought to assist him with the trial within a trial, because it was just kind of dropped on Ramosepele, and he was like, this was a lot of work, this was too much for him, and he sought help. And Ngomezulu, the late Advocate Ngomezulu, may his soul rest in peace, answered to the call of duty, and he did it. Okay, he did it. And even after that, even after getting wind of not being paid for his work during the trial within the trial, he didn't slacken. Okay, he didn't change in his regard for the quest of justice for the accused. But that's another example. And then we go to the third example. Let's use this. Let's go to the third example. Ramosepele in December, the 10th of December, 2024. News suddenly came that his advocate, the late Advocate Ngomezulu, had suddenly passed away, which left Ramosepele with no legal representation, and legal aid jumped up and volunteered to take over his legal costs on condition he picks one of the 4 accused advocates who are already on the defense team, and he has to do it within 2 days. And then that, in the end, he ended up being represented by Mzansi Unfiltered to date. Okay, those are some of the examples of where legal aid has kind of been there, okay, inside Phakathi in the SENZO MEYIWA trial, and the restraints that we have seen, okay, or assumed. It has never been put out in black and white, But now to actually hear to actually hear Attorney Ramosepele say, I didn't say it, okay? He said it. You heard it. Rewind it. You'll hear it. He says, unfortunately, due to financial constraints, I cannot hire a forensic chartered accountant, but I haven't given up. I'm not going to let it go. I've sought a friend of mine in her personal capacity who works at one of these institutions, and I've asked her to go and check with her bosses if she can be given access to backdated records. Now, if I know how superiors work, and we don't know how high ranking she is, this friend that Ramosepele had, it is not a court subpoena. So the company is not obligated to provide that information. In fact, they'll say, we only backdate 5 years. We only backdate 7 years. But had they been a subpoena, it would have frozen that data. We've heard that from Pinky Van Dillingham, the Vodacom expert, that anytime a subpoena comes in for a Section 205, that data is downloaded and kept. No matter what, it's no longer deleted from the database. It's now always there. Then the question becomes, since there is no budget, what I assume is legal aid gives the defense team a specific budget because, they're under legal aid. They're being paid by legal aid. Maybe they're given a little bit of a budget of leeway. But that is it. There is no additional money. And no, they cannot take donations from members of the public jury who want to assist, because then they have to account where that money is coming from. To me, it sounds like a double-edged sword. And my question to you is it therefore a free and fair trial? If the purse strings are held very, very, very tight, my question is, does the same apply on the state side? Does Advocate Baloyi have an unlimited budget, or he too has to face financial constraints? Let me know your thoughts in the comment section down below. But let's, of course, listen to how Advocate Baloyi responds.
Mr. Baloyi, what's your view?
As a court case, my lord, my learned friend submitted that if he accepts the exhibit, he'll be bound by the contents thereof. He doesn't have to accept anything, my lord. At this stage, the states want to hand out this document in terms of Section 236.
Just read 236 so that we all know what you're talking about.
And we submit, my lord, that the document is on all fours with the provisions of Section 236. It reads as follows: proof of entries in accordance in accounting records and documentation of banks. Subsection 1. The entries in the accounting records of a bank and any document which is in the possession of any bank and which refers to the said entries or to any business transaction of the bank shall, upon the mere production at criminal proceedings of a document purporting to be an affidavit made by a person who in the affidavit alleges, firstly, that he is in the service of the bank in question, secondly, that such accounting records or document is or has been the ordinary records or document of such bank, subparagraph C, that the said entries have been made in the usual and ordinary course of the business of such bank, or the said document has been compiled, printed, or obtained in the usual and ordinary course of the business of such a bank, and D, that such accounting records or document is in the custody or under the control of such bank. B, prima facie proof at such proceedings of the matters, transactions, and accounts recorded in such accounting records or document. Then subsection 2 of the section provides as follows: any entry in any accounting record referred to in subsection 1 or any document referred to in subsection 1 may be proved at criminal proceedings upon the mere production, and the emphasis here, my lord, falls on upon the mere production at such proceedings of a document purporting to be an affidavit made by any person who in that affidavit alleges that A, that he is in the service of the bank in question, B, that he has examined the entry, accounting record or document in question, C, that a copy of such entry or document set out in the affidavit or in the annexure thereto is a correct copy of such entry or document. Then subsection 3, any party at the proceedings in question against whom evidence is adduced in terms of this section or against whom it is intended to adduce evidence in terms of this section may, upon the order of the court before which the proceedings are pending, inspect the original of the document or entry in question and any accounting record in which such entry appears or of which such entry forms part, and such party may make copies of such document or entry, and the court shall, upon the application of the party concerned, adjourn the proceedings for the purpose of such inspection or the making of such copies. So subsection 3 gives the party against whom the document is sought to be used the authority to approach the bank to inspect the originals of the entries. We therefore submit to my lord that bank records are upon submission, prima facie proof of the transactions recorded therein. We therefore, my lord, submit that this document ought to be, at this stage, accepted into the record as evidence, as prima facie proof of the transactions that are recorded in this exhibit.
Yeah, just for my edification, this record, which purports to be a true reflection of the banking details of that particular account, starts from which date? Is it from the inception of the account being opened or what?
The statement is for the period 25 October 2014.
25?
25 October
2014.
yes,
Right.
to 28 October 2014.
And it's in respect of one account, not various accounts, just only one account.
Indeed, my lord, but I see if one looks at the transactions,
Yeah.
they actually cover the period 31 January 2014
January 2014, right?
up to 31 December 2015.
2015, okay. So, Mr. Ramosepele, what is the objection?
My lord, as I state, my instructions are this. Accused number 2 states that he had certain ceremonies to perform. Therefore, he obtained a loan from this bank, Capitec, to do the work that he was supposed to do. Firstly, we've gone through this, and an accountant has gone through this as well with me. We don't see that loan amount reflected
If it's
here.
not here, then it was never made with a bank. What bank is it? Where you make a loan and it's not reflected in an account. It must be in another account.
That's the
I mean, this is simple accounting principles.
Yes,
If you make a loan against an account,
yes.
it must be reflected in that particular account, unless you make it in another account of a different account number. Then I can understand. Now,
That's-
are you saying that loan was made in respect of this account? What's the account number? They just give us the account number. What's the account number? It says Capitec.
Yes, it's Capitec, and
Account number?
the account type, it's a savings account.
Savings
And
account.
yes, the account number is 135 64 12 988.
Now, Mr. Ramosepele, your client, you can take instructions. Did he make a loan against this account number?
I did verify that, my lord, that at that time, Capitec only knew this type of account, that is the savings into which the loan was deposited. Because I thought also there's perhaps a loan account into which it was placed.
My question is,
Yes.
was the loan made against this account 1356412
I can verify that, but
Yeah,
I
please.
had previously taken it.
Because I can understand, these things are electronically done. It's not like counting sheep in the crawl.
And there you had it from Judge Rata, the chartered accountant. It is either from another account, but definitely not this one. Ramosepele has to verify that with Obongani Mzansi. Was the loan at this account or did it go to another account? It doesn't matter. At this point, legal aid is still not paying for that verification. And now Advocate Ramosepele has to also become a chartered accountant, just like Judge Rata. Is this free and fair? As I've asked previously, let me know your thoughts in the comment section down below. Let's continue listening on.
as it pleases the court, my lord, I'm indebted. The very same instructions, my lord, that he only had one Capitec bank account into which the loan amount was deposited. And like I'm saying, it's not reflected on the statement. And also, if we
When
look-
was it deposited? Because according to the state, this account became operational from the 31st of January 2014 to the 31st of December 2015. Was it that loan made during this period?
let me take instructions, my lord. My lord, perhaps if I ask for a 10 minutes adjournment so that I can fully take instructions rather than go up and down.
Yeah, fine. But listen to what the bank says.
Yes.
And this is a savings account statement to your client, dated the 6th of September 2023. No transactions for the statement period selected. Transactions not yet processed on your account up to the 28th October 2014. There are no unprocessed transaction items. Transactions before the 1st of April 2018 amount inclusive of 14% VAT. Transactions from the 1st of April amount inclusive of 15% VAT. Checks not yet processed on your account up to the 28th of October 2014. There are no unprocessed check items. And then they tell you the available balance.
Yes, I have gone through that with him, but let me finalize instructions, my lord, then we'll come back.
Okay.